All right, everybody, welcome to the Creative Finance Collective. This is the time where we get together to discuss creative finance and all things pertaining to creative finance and in our state here in Arizona and other states as well. And as we wait for other folks that are participating in the collective, while we wait for them to join, we'll go over a couple ground rules. If you're watching, again, we're talking about creative finance. So if you have questions, we're taking questions throughout the entire hour, or if nobody asks any questions and we're tired of talking to each other, we might just shut it down and hit the road. And I don't know. Alan's out in Texas, so we can't go get a beer with him, but that's what we would elect to do if he were here. So if you don't want us to do that, make sure to put your questions in the chat. And again, we're taking questions about creative finance, creative financing, and all things pertaining to that. With us today, we got Sean St. Clair here in Scottsdale, and Alan out in Texas. Alan, how you been?
Real good, real good. Um, I'm still wrestling with that same litigation matter that I've told you all about previously, and we've got a hearing Friday, and I'm hoping that that's it for me. I'm officially retiring from the litigation world.
Now you've made those promises before, I'll bet.
It's been this has been rough.
How long has this been going on?
It had its 2-year birthday 5 days ago.
Oh,
It was supposed to be a 2-week endeavor.
yeah. Oh man, did you think it was just going to go by default, and that's what and nobody would contest it?
No, the the trustee didn't notice himself. He didn't get authorized to conduct the foreclosure, and I thought, well, that's obviously a very severe flaw. And I figured any rational thinking person would, uh, want to rescind that as quickly as possible before they start getting complaints and such. And then about a year into it, I get a bulletin from an underwriter, and it says, "Don't close any transactions involving this fella, the trustee I'm suing." And so I'm thinking I got a bad fella, a bad guy on my hands.
Wow. Oh, well, no matter what they say, litigation's going to take longer than than expecting. So, what's the creative finance world looking like in Texas right now? Still busy?
Yeah, yeah. So it's busy, and like we said, I think 2 sessions ago, maybe 3 sessions ago, there's a substantial more uh, uh, agent reach out trying to get into the everyday sector of this stuff. So the conventional end user seller, end user buyer mortgage wraps, and we're busily trying to create a structure that's going to resemble the old school structure. Well, for us, Texas Land Trust. I don't know, do y'all use trust still for that stuff?
No, we don't. We don't use land trusts.
So I think we're going back to that, and I don't want to say this necessarily too loudly, but I've had 2 instances of due on sale clause issues, and
Oh,
so that's why I'm trying to create a vehicle that is near the Texas Land Trust, but just a little bit different with some partnership stuff in it.
What kind of lender? What size of lender was it that called the due on sale? Was it your conventional, Fannie Mae, Freddie Mac, or was it like a portfolio loan with a smaller lender?
It wasn't portfolio. It wasn't one of the big boys, but it was a just regular conventional lender. And the issue came up with insurance. Of course, they sent the
Okay.
insurance in, as entity as the primary insured, and the guy we use for the insurance says you have to put the owner as the primary insured, and so it's just it's one of the things that are remain problematic with mortgage wraps, and so we'll let everyone know if we fix it.
so we've already spurred a couple questions. Let's take a look at them. One of them, when you said land trust, we got a land trust question. But before that, from the same person, what liens should I be responsible slash not responsible for paying for on a subto transaction?
So are they asking about solar liens and things like that, or
Well, they ask liens generally. So what liens would I be responsible, not responsible for paying for in a sub-2 transaction. Some of this might come down to what you agree to be responsible for and what's not. It probably boils down to your documents.
Yeah. So I just now got off the phone with someone that said, "Hey, we're going to put this in a trust, and we don't want a promissory note, and we don't want a deed of trust." And I said, "Well, if the seller says that they're fine with not having any redemption rights, any right to foreclose, any right to come after you for a breach, then sure, we can craft some documents for you. But obviously, the seller is not going to approve that." He was trying to avoid having any kind of debt related to him. I was like, "Well, I want that too. I don't want my mortgage company able to come after me." But we see people say seller's responsible for the seller lien still. We see them say buyer. The HUD liens, there's a lot of those now. And so we see people taking those sub-2 and they're forgivable. So they're hoping they get forgiven at some point in time. But generally, in a distressed seller situation, buyer's paying for everything, mostly.
What about a judgment? Would you acquire a property subject to a judgment?
So in Texas, our homestead laws protect us from the judgments. So we have a 30-day removal process for those. I have seen just recently, actually, it was a tax lien.
Yeah, that was going to be my next question. Then what about tax liens?
Yeah, the buyer took it uninsured and gave us in writing that they're going to take it subject to that tax lien, and they're waiting because that tax lien is going to drop off in about a year.
Right.
So that's obviously a little bit more dangerous, but I've seen that, and I've seen people do the same thing with mechanics liens. When that's going to drop off in a year or so, they take it sub-2 and move it over to Schedule B.
What about HOA, unpaid HOA assessments and, even judgments, that type of thing?
So we see people put those over on Schedule B when they're doing a fix and flip or, a short-term hold. They'll defer the payment till they getting ready to sell it. Don't see it in many other occasions besides that. More of just I'll pay you later, short term.
So I've got a couple.
So basically, you can close on with it remaining against the property. You just make. So basically, you can close on anything subject to. You just have to remember that you may be responsible for it if they be aggressive and start foreclosure or something like that. You are going to keep the property if you keep some of this stuff in place.
Yeah, we see a lot moved over to Schedule B, but for the practitioners out there, just make sure you get a real good disclosure and waiver in writing that says we understand this is going to be on our property and they can come after us and they can take our property. Just got to cover your own rear.
Yeah. Let's see. See if I can bring back Sean. Sean, if you can, you got some connection issues, so you might want to reconnect and see how that helps. We have a couple other questions, so maybe we can get Alan a little bit more. And I know we discussed this a couple weeks ago about the land trust, but we're getting a question: when should I use a land trust for a sub-2? And in the past we would have said. We might have said, well, a land trust is something that is valuable potentially depending on what state you're in for anonymity purposes. In Arizona, they don't work all that great because of certain disclosure requirements that we have when we convey real estate into a land trust. But I guess in Texas, when are you thinking you're wanting to use a land trust in a sub-2 deal?
So on that last one that we had where it was an LLC that took the property. Then the insurance caused the mortgage company to start asking questions. We went ahead and put that property over into a trust, and then cited the Garn St. Germain Act and said, "All right, well, good, we're fine now," and that fixed it. And so I was going to say, "All right, let's don't put them all in trust," because the Texas Land Trust is a passive trust, and so beneficiaries have to sign off on documents still. Checks are going to be issued to the name of the trust, and they don't usually have a bank account, things like that. But I think we're going back to them now. Seeing, I think 3 over about a 3 or 4 month period has caused me to get a little skittish.
And you think the land trust helps with that because of the Garn St. Germain Act, because they see that as an estate planning trust?
Yeah, yeah. The document that we show to them shows the proper creation of the trust with the borrower as the beneficiary, and then once we're done with the mortgage company, that's assigned over.
Got it. Sean, I'm curious, we haven't talked really much about this recently, but has this been something you've seen in your practice at all?
I'm not a huge land trust fan, just because in Arizona they don't work that much, but I would rather see, and obviously in Texas you can't do this, but I would rather see an agreement for sale here in Arizona than a land trust. I just think there's more it's more favored, if you will, here, because you don't, with the land trust, it's like, well, you have to disclose the beneficiary on the deed anyway. And then second, if you're going to do a wrap, then you're going to do a promissory note and deed of trust. And if that deed of trust is recorded, then the lender could see that and be like, well, title did transfer to this land trust. And why is there this deed of trust, being issued whereby the land trust is agreeing to pay funds to the seller? How would you, and maybe I don't know how to structure properly, but how would you structure the deed of trust so that, the bank out by looking at the deed of trust or mortgage and be like, well, wait a minute, land trust agreeing to be a borrower?
A private cash out refi? I don't know. Maybe injecting too much wisdom into a mortgage company.
So I like the agreement for sale, but you can't do that in Texas.
No, so that'd be the equivalent of our contract for deed, and if you're going to do that correctly, you have to get permission from the underlying lender to do that, which obviously we're not going to get that.
Yeah. We have another question from Luke. How can I protect
in Arizona
myself from
we don't have to.
Okay. So we have another question from Luke. He asks, how can I protect myself from the due on sale clause or prepare for it? What do you guys think?
I mean, the best way, in my opinion, is to start showing that Garn St. Germain Act and show your declaration of trust with the beneficiary being the borrower. It's not foolproof. It's not bulletproof, because if they wanted to come back and ask, all right, has the beneficiary interest been transferred? Likely you would have to say yes, but I don't think they understand it enough to ask that.
Yeah, it would require, what you're saying there is it would require the lender to take the next step beyond just looking and say, okay, well, the Garn St. Germain allows you to transfer for it to a trust for estate planning purposes. It would require them to go beyond that and say, okay, we want to know more. Yeah. Was this basically essentially for estate planning purposes, right?
And we have one closing right now. It confused me for a little bit. It was in a family revocable trust. And so I thought, well, gosh, I wonder, they must have put it in that, getting ready for the closing or something, but it wasn't. I mean, it's a 1.2 $6 million house. They just had put it into a revocable trust. So now we're going to be deeding it from revocable trust A to revocable trust B, and it shouldn't cause any type of concern at the bank level.
Yeah. We have another question. I think I can probably handle this. Confident that I can. What's the difference between a promissory note and a personal guarantee? Now, if you were to have watched, this tells me this is not a listener to our podcast earlier today. Sean's legal update was on personal guarantees, but the difference between a promissory note and a personal guarantee, a promissory note is a negotiable instrument that evidences the loan on most, well, really on all lending type transactions, and that is a document that is going to be between the lender and the borrower directly. The difference between that and a personal guarantee, the personal guarantee is what obligates me personally to pay the debts of somebody else. So let's say the LLC or an LLC that you set up is the borrower on a promissory note, but the lender's not comfortable with the fact that you put ABC LLC on this document, and they want personal liability behind it. The personal guarantee is you agreeing to be liable and personally guarantee the debts and obligations of another person or another entity. That's really the difference between the two. You obviously don't need the personal guarantee if the transaction is just between the bank and you individually. That's already direct exposure. But the examples would be, day-to-day consumer examples are I'm 18 and I want to go get financing on my car, and they want mom and dad to come personally guarantee it. And so I'm responsible and they're also responsible. Or in the lending context, the LLC with the personal owners also borrowing it. You would also see that in a lot of commercial real estate landlord tenant transactions where the business is going to lease the space, but they don't want just the business, if it's a brand new business, to be the only ones liable. Let's see. Another question. Don't most states make HOAs super liens? I don't, I think what they mean by that is giving the HOA lien super priority. I don't know what most states do. What do they do in Texas, Alan?
It's not a super lien. That would chill mortgage companies to give mortgages for purchase. So there's they can have higher priority lien interest, but the great majority of them have a document that says we're behind the mortgage company.
Yeah. Yeah, no, and here when we think in Arizona super priority liens, it's usually we're talking about county tax liens.
Yep.
That's pretty much it, I think. I ran into this one time. It doesn't have to be real estate tax liens. It can also be county personal property tax liens. So if there's a tax lien against business assets, I've seen that be an issue. All right, let's see. All right, another question. Wow, we're really going deep here. If there's another recession, do you see it hitting the sub-2 community hard with due on sale clauses? So I think the idea here is if we get a deep recession or things get pretty tough, our lenders going to start really sniffing out due on sale clause violations and calling the whole farm due kind of thing.
So I don't like giving my answer on a recorded session here. However, it's my opinion that mortgage companies aren't going to convert from lenders to real estate companies. I just don't think they're going to do that. I mean, how are you going to sniff them out? There's 254 counties in Texas. Are you going to check every county for every loan in every county every month? So it's my opinion that it won't, and then this will get thrown back in my face here in about a year and a half or so.
Yeah, again, for those watching, we're just we're just lawyers, so we're guessing. I mean, there's big practical realities behind how this plays out, why they don't want to or why they do. Um, I think, it's hard to say, but that requires manpower. And if you've got a deep recession, what are lenders doing? They're shrinking manpower oftentimes, just because things are getting more expensive and the economy's tough. So that's a hard thing. Now, what's interesting is just because we're in a recession doesn't necessarily mean uh, affordability gets better. In fact, it can exacerbate things like housing affordability, which spur on the benefits of things like buying subto in the creative finance world. And I thought, this illustrates some of this. This might be a good time to bring this up, but the CPI inflation data came out this morning just for the month, and it came up slightly higher month on month, so like 0.1% month on month inflation. But year on year was basically 3.1% inflation. Of course, there's some other figures behind that, but one of the things that they note is that it's not a deflation type of scenario, it's disinflation that's happened. In other words, the rate of inflation's going down, but prices are still rising. So affordability still keeps getting worse. So you could have situations where recessions happen, but we're in unique economic times where that are followed by extremely cheap money with loans that are in place. And I guess, some of the listeners' concern is, well, calling these loans due would benefit the lender theoretically and force people into higher paying loans. But that's assumed in that situation, they could even climb into new loans, so on and so forth. But like, I think to your point, Alan, a lot would have to happen, practically speaking, for them to really want to do that. And to do that, I guess your bigger point is it makes them a real estate company, right? They become a real estate holding company at that point, right?
Yeah, yeah, and I don't think they're, generally speaking, too good on that job.
Yeah. Well, they don't want it. I think admittedly that's not a job that they want. Their job is to make money on lending, and that's how they do that. Let's see. We've got another question. Question: do we wait to see if they hit us with a due on sale clause, or should we transfer to a trust prior? I think the question, yeah, basically is, should we plan for this now or just wait to see if it gets called due? What are your thoughts on that?
So originally, I utilized the trust as a fix instead of the deed back and forth. It's more of a, I think in my opinion, it's more of a permanent fix. However, maybe the reason that I'm moving more towards the trust is we're attempting to get those mainstream mortgage wrap transactions. We're looking at, like I said, $1.6 million. We have a $3 million seller finance wrap coming up. So these people might be a little less, have less of an appetite for corrective measures post close. So if I'm a betting man, I think we're going to end up utilizing the land trust initially as opposed to a fix, at least on the consumer ones.
All right. If you're just now joining us, thank you for watching. This is the Creative Finance Collective, and on it we have Alan Seschker out of Texas, Sean St. Clair, and myself out of Scottsdale here in Arizona. And we're talking about all things creative finance. If you have questions, make sure to post them in the chat. We're going to take questions for as long as you have them throughout the hour. Looking to see, just checking the questions here. A couple other data points, I think, as we go forward into 2024, because this is really the last month of this is the last month of 2023 as we move into 2024. So thinking through some of this data, but there's been a real question about what the Federal Reserve does, whether they pause, well, they have been pausing, whether they continue a pause, whether they raise rates or whether they reduce them. Some interesting, in addition to the 3.1 inflation data that came out, and inflation is kind of trending today as a topic. The underlying data that was beneath that figure I thought was interesting, and I wanted to read that real quick. And I think it gives some background as to why I think we're going to continue to see subto and creative finance be popular. But car insurance inflation came in at 19.2%. Transportation inflation 10.1%. Car repair inflation 8.5%. Rent inflation's at 6.9% as of today. Homeowner inflation 6.7%. Food away from home inflation 5.3%. Electricity inflation 3.4%. In other words, the 3.1 inflation number that they want you to see is not quite as healthy as the day-to-day stuff that all of us consumers face on a day-to-day basis. So you can really see a scenario where, especially if the Fed pauses, as they have and continues that, this isn't, these indications suggest we're going to be seeing this kind of environment well into next year. Now, maybe the interest rates come down and that spurs selling, and maybe that brings down prices. But while prices are high and cost to borrow is high, I don't really see a better avenue than creative finance. And it sounds like, Alan, at least in Texas, it hasn't slowed down at all.
No, no, and Austin's a little bit different, but it's still going fast. I mean, if you're in the solely in the consumer side of title work, you're not having as much fun. But if you have an investor based business, also they're out there looking for the deals. Still, there's a lot of people who have money on the sideline and have been waiting for this. I got a lot of folks who are waiting for the commercial loans to start coming due. Those balloons are going to start coming due. I forget the exact numbers. We just went down to the Land Title Institute, and for 24 it was big, and 25 even more of those coming due. So I think that's going to rock the commercial world quite a bit.
Yeah, I don't do a little bit of commercial. Well, do some commercial work, but they're definitely of the investors and of the folks that are in the space. Commercial seems to be the loudest, or the one that everybody seems to be waiting for something major to happen. The residential's got this buffer of the fact that so much of the population is sitting pretty on cheap mortgages, and so long as job data just doesn't completely turn around and half the world lose their jobs, the residential side seems strong. So it's like you mentioned, Alan, these balloons that everybody suggests are coming. With the commercial side of things, appears to be what a lot of folks are waiting for. Let's see, we got some more questions. So what's the procedure when someone declares bankruptcy when you've bought their property subto? So the seller files bankruptcy.
So
Some of this should have been planned for in the documents, right?
Yep. That's exactly what I was getting ready to say. I've got, and it's probably shortest, weakest document I got, and it's just simply an agreement to reaffirm, and that's what needs to occur. I've seen on I forget if it's one or two occasions where the buyer did have to come in, get a bankruptcy attorney, and tell them, hey, you need to reaffirm this thing, but nothing blew up. So while you would expect that to be a very serious problem, it's not so far.
Now that's on a traditional subto with a warranty deed and wrap. Things become more complicated on contracts for deed, agreement for sale, because that's an executory contract. which means the trustee has the right to come in, refund the buyer whatever they've paid out. So any down payment that they've made, and then it would be the basically they would refund the buyer any amount that they've paid on the mortgage that would be in excess of like the fair rental value of the property. Otherwise, they don't pay them for the monthly payments, and they give that
Oh,
back to the
I see.
they give that back to the buyer, and say thank you. We get the property now, and we're going to sell it for the benefit of creditors. So that's the problem with executory contracts, like contracts for deed and agreements for sale. Is, in my view, and I've never seen a lender pursue a due on sale for that type of structure where the deed remains in the seller's name. But if that seller files for bankruptcy, you as the purchaser may have an issue because the could step in, liquidate that property, and take it from you.
Huh. That is what they do. Now I think about it, there's case law on our lease purchase options, longer than 180 days, can't do them. And they state in the statute, if you do, then you can undo that transaction and have to return all the money that was paid to you by this buyer borrower. But case law came behind them and said, no, you got to pay your fair market rent at least. And so they deduct that portion out. So
Yeah.
same thing here.
Yep. So, right, because presumably you just have possession and that's what you're paying for. So they figure out what the fair market rent is. So, yep, that's exactly what they would do in bankruptcy. So, not a great, option there, but the contract for deed agreement for sale, at least here in Arizona, is a good alternative if you're concerned about the due on sale clause. And it's kind of a gray area, but my understanding is it gives you the same tax benefits as an actual, warranty deed purchase, or fee purchase. But it's kind of the middle ground between warranty deed, wrap, and your lease with option to purchase back end, which doesn't give you any tax benefits and can easily be set aside in bankruptcy. You're kind of in the middle there. And it's still, even though I haven't ever seen a lender invoke the due on sale clause, the Fannie Mae Freddie Mac due on sale clause is very clear that that would violate it. That would fall within the due on sale. In fact, I think it even uses the language contract for deed in their, due on sale clause. So,
Yeah. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour, so we'll be here as long as you're here to answer or ask questions. We'll be here to talk about that, and we're talking about all things related to creative finance. We have another question here. Let's see. What should I watch out for when wholesaling probate property or property that's presumably in probate? What do you think? Make sure you're assigning it to the right person.
Yeah, we just got one, and I got taught a lesson from one of my escrow officers. You had letters testamentary, you had a independent administration all squared away, but there wasn't a will stating that an administrator can go and sell the property. And so since that will didn't exist and didn't have that magic language, all the heirs had to come and sign off on the deeds. And so there was 6, and you, of course, you'll know where this is going. 5 were willing to do it, and the 6th one wasn't.
Of course.
And so now the client's asking, what are my choices? And your choice is to either get them or file suit to quiet title. Sometimes neither of those are appetizing.
interesting. Arizona's a little bit different. If you have those letters testamentary, you can sell the property. However, if you have multiple heirs, and you're just one personal representative, it's recommended to go and obtain the heirs' consent to the sale so that there's no objections later on. And if you can't get their consent, you can always go into court and apply for approval for the sale. But technically, the personal representative has the full authority with those letters to sell it, and then it just goes into the pot and gets the liquid assets get distributed at that point. So that's interesting that Texas has that. I know Texas has a lot of. It's a lot easier to convey property by affidavit in Texas than it is in Arizona.
Yeah, yeah. How do y'all deal with the if you haven't finalized probate and you're going through the AOH process, who do you have sign off on the contract?
What's the AOH? I don't know what the AOH process is.
Well, the affidavit of heirship isn't completed yet, so not ready to be filed
Oh,
or not filed yet.
so okay, so yeah, interesting. So in Arizona, there's three basic types of probate and ways to transfer the property. So the first is um, what we call an affidavit of succession to real property, which the equitable interest of the decedent has to be less than, I think it's 125 now. They're always changing it.
Yeah, they keep upping it. That's about right, I think.
I think it's less than 125, and the decedent has to be dead for over 6 months. Then all heirs can fill out this affidavit, and whether heirs by will or heirs by intestate succession, they then can take that affidavit, file it with the probate court, and our probate registrar, so not even a judge, but a registrar, looks at it, makes sure everything's in order, stamps it, and then you pick up a certified copy of that affidavit and you record it, and that's the transfer. No probate proceeding. You have to get approval from the probate registrar, but no probate proceeding. If you can't transfer it by affidavit of succession, then you have to do what's called an informal probate, where, assuming you can, if you have a will and no disputes and whatever, then you can do a informal probate. The probate registrar signs off on it, has a judge sign the letters, and then at that point you can sell. You don't need any affidavit of heirship. You don't need any other documents. All you need is the letters, and the PR can sell it. So certified copies of the letters. And then if there's disputes or you don't have an identifiable personal representative, or otherwise you can do a formal probate, which is overseen by a judge, and they'll issue the letters after a hearing. And then once those letters are issued, the PR can sell it, but there's no affidavit. The affidavit is only a kind of a one-step process to deal with real estate, and there is no probate if you use the affidavit.
Yeah, and the biggest downside, maybe you mentioned this, Sean. The biggest downside of the affidavit is it's of course designed for small estates to avoid a lengthy probate process, but you have to be able to testify that you have no unsecured creditors, and you have to wait 6 months. Don't you have to wait
Right.
You have to wait 6 months.
6
So
months. Yeah. Mm-hmm.
yeah, so like assuming it fits all that, and that sounds great. If you're trying to move on a deal, that's where it can be a real problem, because you have to wait 6 months from the date the decedent died. If you've got something hot or you need to move, that's when you, if you want to move in that 6 months, you're going to have to get the PR appointed. And once they're appointed, they have authority on behalf of the estate, can enter into contracts, sell that. They can do it right away.
Do y'all have difficulty with your people getting access to the mortgage information? The mortgage companies often will say, no, you got to go through probate. We're like, no, we have an affidavit of heirship and a death certificate, and then we start fighting.
Yeah, we do have those issues. Generally, once we have the letters, then the PR can get access. But on affidavits of succession, that is true. In fact, we've had couple of mortgage companies like, oh, well, when are you going to pay us the full mortgage because the borrower died? It wasn't a reverse mortgage; it was just a straight up loan. When are you going to pay us? We're like, we're not. Darn Saint Germain, we don't have to pay you anything. You know, and so yeah, we've conveyed the property by affidavit of heirship, or plan to distribute it to the heirs out of the probate because they wanted to keep it. And then the mortgage company shows up with their handout wanting a full payoff. And we're like, yeah, it doesn't work this way.
We have had when we have a mortgage wrap or subto, we get current statement from the mortgage company, reinstatement if it's applicable, payoff statement, and also a copy of the note. And we have had a bank come back and check on us. Hey, we gave you that payoff statement. When are y'all issuing that payment? And so we may adjust our processes a little bit there. If we've got the principal balance on a current statement, we'll use that as an estimate, possibly. Just seems like they're getting more skittish a little bit.
Well, it's because it's becoming more mainstream and there's more, numbers and people doing it, that I think, I'm not sure what the business decision is, or if there is a business decision. I think it's almost like a principle type decision that they're making. It's kind of like short sales. There were a lot of decisions that were made that made no financial sense at all during that whole era. And I think this could be one of them. Like, oh, well, we're going to invoke the due on sale clause despite the fact that we're getting our monthly payments, and another person or entity has reinstated our loan and is now paying us on a regular basis going forward, and has agreed to pay us on a regular basis going forward. We still don't like it, so we're going to do something about it, which once again doesn't make financial sense, but maybe that's just the way they're going to operate.
And do they just not like it as a knee-jerk response? They don't think it through, but
Yeah, I think it's the same thing with the short sales, that they were so difficult for so long in the short sales, and you ended up with a bunch of foreclosures because they were just didn't want to do short sales for the first 2 or 3 years, and those foreclosures were reaping like a third of what they were being offered in a short sale. And but it was their principle, what they thought was the right thing to do, despite the fact that when you run the numbers, it made no financial sense whatsoever.
If you're just now joining us, this is the Creative Finance Collective. We're taking creative finance or real estate related questions throughout the hour, or so long as we're receiving questions. We have another wholesaling question. Sean, you might have thoughts on this, and Alan, maybe you too. When wholesaling a deal and I can't find a buyer, how could I get the earnest money back?
Cancel in your inspection period, or let the seller have the earnest money. That's the cost of doing business.
you can plant extra ways out in special provisions that we've done. That gets as creative as your imagination. You can even specify, I'm wholesaling, and now we have a statute that's going to be effective January 1. But before you went out and advertised the property, you had to advertise it as your equitable interest that you're selling. They added 4 words total. The disclosure has to be in writing. So I guess I had some problems there with people saying, I told them verbally. And then not only do you have to tell the prospective buyer, you have to tell the seller that you're selling your equitable interest. Not certain how that actually works, though. You have a written contract that creates an equitable interest, so you're going to tell them I have an equitable interest. So
Yeah.
I think they missed it on that one for Texas.
Yeah, Arizona did a very similar thing, where they have this disclosure language, and then they say, okay, you have to disclose to the seller that you're a wholesale buyer, which is fine. And then you have to disclose to the new buyer that you're a wholesale seller. I'm like, the new buyer? Who's the new buyer? And and it says, and you have to disclose that in the purchase contract with the new buyer. I'm like, the purchase contract, there is no purchase contract with the new buyer. It's an assignment. So it was very poorly written and made no sense. But we've kind of, in the legal realm, interpreted the statute to say, okay, well, make sure to put wholesale seller language in your assignment, which basically says, hey, I only have equitable interest and blah, 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 blah. And, putting that in the assignment. But you're nicer than I am as far as, and I help clients out. Obviously, I represent whoever I draft stuff for, and put provisions in there as far as getting the earnest money back. But I'm kind of the opinion, hey, if you're going to wholesale, set up an inspection period. If you can't find somebody in that inspection period to buy it, you better cancel. Or otherwise, why wrap up a seller's property for 30 days without any skin in the game? I don't really like that, just from a right or wrong scenario, if you will.
So
I agree 100%. Yeah.
yeah, so a follow-up question. What's the difference between a cure notice and an inspection period?
Well, an inspection period is a period that you have to inspect the property, to inspect the neighborhood, to decide if you want to move forward with the transaction for one reason or the other. And if during that period you serve a notice upon the seller saying, you're just not satisfied, you don't want to purchase the property, then you can cancel it and receive a return of your earnest money. Now, two things, right? And in Arizona, if you deliver that notice to the title company, to the escrow agent during the inspection period and say, I'm canceling, please, pursuant to my inspection period rights, please return the earnest money to me. They return the earnest money, and you don't need anything from the seller. I don't think that is true in Texas. I think Texas, you guys require the seller to sign off on, say, yes, the buyer canceled in the inspection, and they get their earnest money back pursuant to the contract or something to that effect, or, release their earnest money. In Arizona, we don't require that. That's not required at all. But that is the inspection period. You cancel and your money comes back. A cure notice is simply a document that is served by either the buyer or seller upon the other party, when that party has not timely performed its obligation under the contract. So if you have a close of escrow date of December 15th, and now it's December 16th, and the buyer hasn't delivered the closing funds to escrow, you can then issue a cure notice to the buyer and say, hey, buyer, you failed to deliver your money to escrow and close by on or before the 15th. Here's a cure notice. You have 3 days, 10 days, whatever time period you've put in the cure notice, or in the contract for the cure notice. Here's the period of time you have to perform. And if you don't perform, the contract is canceled, you're in breach, and in this case, it would be the seller would get the earnest money.
Yeah. I don't know why they make us get the seller to sign off on the release of that earnest money when it's in the option period. It's extremely frustrating. People look at us and say it's us. It's clearly not us. It's above us at the agency or underwriter level. I'm going to start putting language in there about the seller releasing any type of claim that they have if we release the money to the buyer if they cancel during the option period. I don't know what underwriter is going to say about that, but if it's a smaller amount, we're talking about $500 or what have you, then I'll take that risk on. But it's frustrating.
Yeah. Well, in our realtor form purchase contract, there is language in there that basically says that both parties give the escrow agent the discretion to determine how to return or deal with the earnest money, and that they then indemnify, defend, release, blah, 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 based upon whatever decision that they choose. Now, let me ask you this, Alan. I know you do some transactions that are non-insured transactions. In that case, would you require the seller's signature to release the earnest money?
So since it's customary, it depends on how many zeros.
Okay.
So the largest one I did was for a very, very good client. It was $10,000 that was at dispute. And I just simply had him sign a document that said, if they come back and ask for it, we'll put it back in escrow.
Right. Yeah. And now I will tell you, the title companies, while it seems, great, if there's ever a dispute, if so normally what they'll do, the more cautious title companies will say, especially if the buyer's in breach and they're going to release it to the seller, they're going to say, we've been informed, that the cure notice has expired and that there's been a buyer breach. Pursuant to the contract, we're going to release the earnest money to the seller on this date. And they normally give like 48 hours. Please notify us if, you don't approve or something like that. And then if the buyer gives them some, legitimate reason why they think that it shouldn't be refunded, or even really any reason, even if it's not legitimate, they give them some reason and say, no, it's in dispute, then the title company will hold it at that point. So if the buyer serves notice during the inspection period, says, hey, refund it, and the seller comes forward and says, oh, well, the buyer was in breach anyway, which I don't know how with cure notices and stuff, but the buyer was in breach anyway, hold the money, don't give it back to the buyer. The escrow agent might throw up their hands and be like, no, we're not going to get involved, figure it out. But really, honestly, in my 20 years of practice, I've never seen a seller object to the return of the earnest money during the inspection period. If the buyer cancels timely within the inspection period, I've never seen a seller or listing agent object, because it's like, well, it's in the contract and that's just the way. Even big commercial deals where you have $50,000 earnest monies. The earnest money, if the buyer cancels in the inspection, it just goes back. Like, everyone knows that that's just the way it happens. I've never seen an issue.
We unfortunately have.
Really?
Yeah, not I wouldn't say often, but it's occasional.
Yeah.
And then we do have a similar notice that we do. It's 15 days. It's hard coded in the contract. If someone asks for their earnest money back, and then 15 days goes by, then escrow can release that to the requesting party.
Okay, there you go. So that's a little bit better.
Yeah.
All right, if you're just now joining us, we're going to be here, well, maybe only for a few more minutes. We've worked through all of our questions. If you have any, feel free to post it. But we're just kind of here through the hour. Alan, this time of year does right going into Christmas, I would imagine things start to slow down a little bit. Have you seen any slowdown, or is it just sub-2 full speed ahead all the way through the end of the year?
So I haven't seen a slowdown in contracts. There'll obviously be a little bit of a slowdown during the close days, but then everyone wants to hurry and close before the end of the year for tax purposes.
Oh.
So December ends up being kind of normal when you average it all out. January, February, that's especially the conventional stuff. That's when it slows quite a bit.
Interesting. Well, hey, we've been doing it for about an hour now. Appreciate your time, everybody. We had a lot of good questions, and we'll do it again next week. Thanks for being with us, Alan and Sean.
Thank y'all.
Absolutely. Thank you.
Talk to you later.
Okay. Bye.